5, 4, 3, 2, 1. A beer reading of the scheme of the aforementioned regulations would show that there is a clear demarcation of quantum of punishment between the minor lapses, delinquencies and acts of misconduct full stop. It is evident that having regard to the nature of acts of omission and commission, the punishment prescribed for minor lapses and delinquencies ostensibly not having perpetual effect, have been made non-appealable in comparison to the punishments for acts of misconduct, which include recovery of whole or a part of pecuniary loss, exceeding rupees 50, cost to the corporation, withholding of increments for a specific period, termination of services, removal, etc., which can all be characterized as major punishments, full stop. Precisely for this reason, all the punishment falling in the latter category have been made appealable, full stop. The perceptive distinction in two sets of penalties, in our view, makes it abundantly clear that the corporation has treated the punishments/penalties falling in the first category as minor punishments/penalties and the acts of misconduct, falling in the second category as major penalties, full stop. We may, however, hasten to add that it cannot be laid as a hard and fast rule that stoppage of increments, with or without hedge over it, is always to be treated as a major penalty, necessitating regular inquiry, full stop. It would depend on the rules and regulations governing the service conditions of the employee. In the absence of specific regulations, withholding of increments with cumulative effect is treated as a major penalty because it has a perpetual effect on the entire tenure of service of the employee, full stop, para. Be that as it may, we are of the opinion that in the light of our interpretation of the aforenoted regulations, the imposition of penalty wide composite order dated 19 December, 1989, directing recovery of loss of rupees 16,913 and 41 paise and stoppage of 3 increments with cumulative effect, is a major penalty, clearly envisaging a regular inquiry before punishing the respondent, full stop. Since admittedly the procedure was not followed, the High Court was justified in coming to the conclusion that imposition of the impugned penalty without holding inquiry was illegal and without jurisdiction, full stop, para. Before parting with the case, we may also deal with the submissions of learned counsel for the appellants that a remedy by way of an appeal being available to the respondent, the High Court ought not to have entertained his petition filed under Articles 226/227 of the Constitution, full stop. There is no gainsaying that in the given case, that High Court may not entertain a writ petition under Article 26 of the Constitution on the ground of availability of an alternative remedy, but the said rule cannot be said to be of universal application, full stop. The rule of exclusion of writ jurisdiction due to availability of an alternative remedy is a rule of discretion and not one of compulsion, full stop. In the instant case, though it is true that the penalty order impugned in the writ petition was appealable in terms of the aforenoted regulations, but having coming to the conclusion that the order was per se illegal, being violative of the principles of natural justice, it cannot be said that the High Court fell into an error in entertaining the writ petition filed by the respondent, full stop. इस वीडियो के डिस्क्रिप्शन बॉक्स में टेलीग्राम चैनल का लिंक दिया हुआ है जहां पे आपको ये PDF प्रोवाइड किया जाएगा।